South Africa has recently seen the suspension of the Public Protector Advocate Busiswe Mkhwebane. This follows an inquiry into her fitness for office and a subsequent decision by President Cyril Ramaphosa to suspend her. I am Busisipho Siyobi, lead researcher at GGA, and here to discuss the matter is my colleague Helen Acton. What is the role of the Public Protector and why is it important?
So the Public Protector is one of the Chapter 9 institutions established by our Constitution to protect constitutional democracy. And the Public Protector specifically is tasked with investigating, reporting on and remedying any maladministration or corruption in state affairs or public administration. So she acts as a government watchdog. She also has quite broad powers because she can choose to investigate, or any organizations can come to her to ask her to investigate, and her findings are also legally binding.
Upon Advocate Mkhwebane assuming office back in 2016, the courts have invalidated her findings in a series of legal reviews launched against her investigative reports. Can you please just explain to us why is this the case and what the legal reviews reveal?
The courts found in the review of her ABSA report, where she suggested amending the Constitution, they found that it was a complete misunderstanding of constitutional supremacy, which is at the heart of our democracy. In the Estina dairy farm case, the court found that her failure to investigate key figures implicated in the scandal was gross negligence and a complete failure and dereliction of duty. That's what the court said. And in her CR17 report, the court found that her conclusions were unlawful and irrational, and they couldn't be found from the evidence before her. And finally, in the SARS Rogue Unit review case, the court was quite harsh, and they said that her report was the product of a wholly irrational process, which failed at every point. So the court has made it very evident that they think she has been incompetent. And then in the form of misconduct, the courts have recognized that she has displayed bias because in the ABSA review case, the court highlighted bad faith, misrepresentations and falsehoods presented in the litigation. They found that she displayed bias in the way that she conducted her investigations, and the court actually ended up ordering personal costs against her for the first time ever. And this also led to criminal charges of perjury by the NPA. In the SARS case, the court was very strong in its opinion that her bias against Gordon and Pillay was manifest, and also ordered punitive costs against her, and then sent that judgment to the Legal Practice Council to have to consider her being struck off the roll of advocates.
So considering those findings, can you explain what the impeachment process entails? What is that all about?
Unfortunately, when all of this happened, there weren't actually rules in Parliament for the impeachment of the head of a Chapter 9 institution. So this is why the process has been a bit slow to start, because then those rules needed to be formulated. So then Parliament formulated a 17-step impeachment process, and then the DA submitted a resolution for her impeachment. There's been a preliminary panel that was formed with a judge on it that was going to look into whether there was prima facie evidence of incompetence and misconduct. And this panel found there was prima facie evidence. And so after that, there's now been established an ad hoc inquiry committee in Parliament, which then will investigate and then give recommendations and reasons as to whether there are sufficient grounds for her removal. And then if this committee recommends that she be removed, Parliament then needs to vote on her removal. There needs to be a 2/3 majority. If there is this majority, the President is then obliged to remove her from her position.
You mentioned that it was quite a slow process to start and there have been a lot of delays. Can you please walk us through what those delays were? And I understand that there was a litigation process in there as well.
So there weren't rules in place. So that was obviously a process for Parliament to formulate these rules and to create this process. Then after that, there was the Public Protector challenged these rules for being unconstitutional. There shouldn't have been a judge on this preliminary independent panel. because this was an abuse of separation of powers. And then secondly, they upheld her challenge that it was irrational and procedurally unfair for her not to have full legal representation during the process. This then went to the Constitutional Court, which then upheld the legal representation argument, but didn't uphold the argument that having a judge on the panel was illegitimate. So the Public Protector then took this finding by the Constitutional Court and launched a rescission application for them to reconsider whether they were right to say that there shouldn't have been a judge on the independent panel. The courts rejected this rescission application, and while that was pending, the Public Protector also launched interdicts against the power of the President to suspend her and the impeachment process continuing in Parliament. These interdicts did not have valid grounds, and that's what the courts found. So there have been delays, valid delays, because of having to validate the rules, the impeachment rules, and to see if they are compliant with the Constitution. But now that has been established, the process needs to forge ahead.
So, considering these recent developments, what are the possible implications for the office?
If she's been seen as someone who is fighting political battles and isn't taking her work seriously, or has been found by the courts to be incompetent and guilty of misconduct, such as bias and bad faith and even perjury, it really undermines the perceived independence of this body, which goes to the core of its function. It also debilitates the democratic functioning, because Parliament is supposed to hold the Public Protector accountable through this impeachment process, and she keeps trying to stall it through going to the courts. The courts aren't supposed to be involved in this process. It's a parliamentary process, and the wheels of democracy are turning as per what the Constitution envisaged, and by constantly returning to the courts as the site of political battles and lawfare, negates the way the Constitution envisioned the accountability mechanisms working.
Thank you very much, Helen, for sharing those insights and analysis. It is very clear that the role of the Public Protector is critical in supporting and protecting our constitutional democracy. For more insights, discussions on policy matters in Africa, please join us again. Don't forget to like and subscribe to our YouTube channel.